Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your options are, and your rights that you have. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offense. Does not mean that they're not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about is I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Now, misdemeanor cases are divided into 3 categories. And we'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that start in the city court or the JP court, and they come to this court when a person is found guilty in that court, and then they get a whole new trial in this court after they appeal their case. I'll give you an example of a Class C misdemeanor. Not wearing your seatbelt is a Class C misdemeanor. Speeding is a Class C misdemeanor. Having an expired license sticker is a Class C misdemeanor. So Class C misdemeanors, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. You cannot get jail time. And the fine cannot exceed or be above $500. So $0 to $500 or $1 to $500 is the range. All right. Now, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service for the Class C misdemeanor, then the court can issue what is called a capious pro fine. A capious pro fine means that it's a warrant for that person's arrest for them to either pay the fine or sit the fine out in jail. And if they sit the fine out in jail, they'll be credited $100 toward the fine and court costs for every 1 day that they spend in jail. All right, that's on the Class C misdemeanor. Now, the next highest misdemeanor is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail. Or a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, a person may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And what that means is we kind of refer to as deferred probation or deferred adjudication. With that type of probation, you don't have a conviction on your record. And if you successfully complete the probation, you can get where your case is going to be dismissed, and you can get what is called a non-disclosure. A non-disclosure means that your record will be sealed to the general public. So the general public can't have access to that offense because it's sealed. Now, when I use the term general public, most of the public is the general public. There are certain agencies like the police department and certain government agencies that are listed in the Code of Criminal Procedure that can have access to it, but most of the public is the general public. So for example, if you're working at ExxonMobil can have access to that if you have a non-disclosure, because they're part of the general public. They're not on the list. They're not a governmental agency. All right. Now, the next type of probation is called adjudicated probation. We talked about unadjudicated probation, and now we have adjudicated probation. With the adjudicated probation, we commonly refer to as regular probation. You do have a conviction on your record. However, there's something that is called judicial clemency, which means that the court, the judge, can set your conviction aside, and you will no longer have a conviction. Now, in order to qualify for judicial clemency, three things has to happen. Number one, you have to successfully complete probation. Number two, there cannot be any more time left on the probation. And three, you have to be discharged or let off the probation by the probation court. If those three things happen, then the court has the discretion to set your conviction aside. Now, everyone here for a case, you should have a clipboard. You have a clipboard? All right, thank you. Okay, right, so thank you. Okay, now I'm going to go over the paperwork that's on the clipboard. Now, that first document is titled, not the little short paper, but that first document should be titled Judge's Explanation of Rights to Defendants Without Attorney. Everyone here today is going to sign that document. Okay, and I'm going to go over this document with you. The document states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three on that document states that you may represent yourself. Those are your three options. You can hire an attorney. If you can't afford to hire an attorney, you can ask for a court-appointed attorney. Or if you want to give up your right to have an attorney, you want to represent yourself, you can represent yourself. Those are your three options. All right. Now, the first paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from today to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first sign a financial questionnaire. The financial questionnaire is a 3-page document that is also on that clipboard, and it is titled Jefferson County Affidavit of Indigence or Affidavit of Indigence. Now, you would have to fill out the first page of that document. And the document looks like this. You'll fill out the first page of that document. And then on the second page, okay. The second page looks like this. It has at the top defendant's oath. You'd have to fill out the top where it says defendant's oath. And then the middle portion says unsworn declaration by defendant. You will fill that out and stop. That's only for people who will be requesting or asking for a court-appointed attorney. If you're not asking for a court-appointed attorney, you don't have to worry about that. Okay, if you want to represent yourself or if you want to hire an attorney, you don't have to worry about that. That's only for people who will be requesting a court-appointed attorney. Now, I will give you time to fill that document out. Now, the next one-sentence paragraph on that first page, let's go back to the judge's explanation of rights to defendants without an attorney. On the first page, the next one-sentence paragraph states that you may not talk to the prosecutor about your case unless you first sign a waiver of your right. Now, this is only for people who will be representing themselves. You have an opportunity to talk to the prosecutor, just like if you had a lawyer, your lawyer would talk to the prosecutor. Now, when I use the term prosecutor, I'm talking about the assistant criminal district attorneys that works for the Jefferson County DA's office. We have 2 of them in court today. If you represent yourself, you have an opportunity to talk to them today about your case to see if you can work something out. All right. Now, if we go back to that first document, and what on the judge's explanation of rights to defendants without an attorney, the next paragraph is in block form. Second to the last paragraph at the bottom. Okay? It's a block form. This is for individuals who will be representing themselves. It states that there are dangers and disadvantages of self-representation. Representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last paragraph, the one-sentence paragraph at the bottom, states that if you represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you decide that you want to represent yourself. And let's say you want to get, you want to work out something on your case. You might want deferred adjudication, unadjudicated probation. And so you talk to the prosecutor. Prosecutor say, well, I'm offering jail time or a fine. Something different from what you want. And you could say, well, Judge, I changed my mind. I don't want to enter a plea. I would like to have an attorney appointed to represent. You can do it. Okay, if you can't afford to hire an attorney, you can ask for an attorney to be appointed to represent you. So that's what that last sentence says. So you can change your mind at any time. All right. Now at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. And that is right at the bottom of this document. Right here. It says defendant's choice, mark initials next to only one choice. Now, everybody's going to place their initials and names on that document on one of the lines. Okay. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left, if you want to hire an attorney. If your choice is, if you have already hired an attorney, then you'll place your initials on the second line and the name of the attorney on the line to the right. If your choice is to request or ask for a court-appointed attorney, then you'll place your initials on the third line to the left. Okay? Now, if you've already been appointed a court-appointed attorney, you place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to an attorney to represent yourself, you'll place your initials on the last line, the fifth line, at the bottom of this document, and then once you've signed or once you place your initials on one of the 5 lines, then you will sign the bottom of this document where it says defendant. You will sign your name on that line and you will date today's date, December 9th of 2025. Okay? Does anybody have any questions? It's just going to be a brief recap. If you are hired an attorney, this is the only document you will sign and initial. Okay, you don't have to worry about the asking for a court-appointed attorney or representing yourself. This is the only one. You're going to initial, sign, and stop. If you are requesting a court-appointed attorney, you'll place your initials on the third line of this first document, sign it and date it, and then you'll go to the Jefferson County Affidavit of Indigence. You will fill out the first page, and then we're going to go to the second page, and you're going to fill out the top portion that is titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. That's it for you. Now, if you would like to represent yourself, and then you will go, if you like to represent yourself, you'll place your initials on the fifth line, sign and date it on the judge's explanation, and then you'll have to sign this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. This is only for people who will be waiving their right to attorney and representing themselves, and they'll be able to talk to the prosecutors about the case. You'll fill out this document, read it, fill it out, read it, and then sign it and date it. And that's it. Okay? So, all right. So, as I mentioned to you earlier, those are the options you have regarding your right to have an attorney. Now, you can enter one of 3 types of pleas. Okay? You can enter one of 3 types of pleas. Number 1, you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. So again, you can enter a plea of not guilty, which means that you're telling the court you did not commit the offense you've been charged with, or you can enter a plea of guilty, which means that you're telling the court that you committed the offense that you've been charged with, or you can enter a plea of no contest, which means that you're telling the court that you will not be fighting or contesting the charges. Now, I'm going to go over your rights. One of the rights that you have, and we're going to give you time to fill out the paperwork. One of the rights that you have a right to have a trial by jury. For those young men are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors to serve as jurors on your case. They will listen to all of the evidence that's being presented by the state and the defense. They will listen to the arguments of the state and the defense. And then the jury will go back into the jury room to deliberate to decide whether to find you not guilty or guilty. Now, you can give up your right or waive your right. That's what it means. You can waive your right, which means to give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, what that means is you would not be having a trial by jury. Now, you still can have a trial, though. You would have a trial, we call it a bench trial. It's a trial by judge only. The reason why they call it a bench trial is because the judge sit on the bench. All right. Now, the judge will be the judge and the jury in the case. The judge will listen to all of the evidence that's being presented by the state and by the defense. The judge will listen to the arguments of the state and the defense, and then the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, if you enter a plea of guilty or no contest and you like to have your case disposed of, then you have a right to talk to the prosecutor to see if you can enter into what is called a plea bargain. Plea bargain is a way to settle your case. Now, there are two types of plea bargains. One type is called an agreed plea bargain, and the other type is called an unagreed plea bargain. Agreed means that you and the state has come to an agreement to settle your case. Unagreed means that you and the state couldn't come to an agreement to settle your case. And so with the agreed plea bargain, that will go before the judge, and the judge will do one of two things. The judge can either accept or reject your plea bargain agreement. Now, if the judge accepts the plea bargain agreement, fine. Now, if the judge rejects your plea bargain agreement, then you can tell the judge, say the judge, well, since you're not following the plea bargain agreement, I take my plea back. And that's, I'm not pleading guilty, I'm not pleading no contest. You're not following the plea bargain agreement, I take it back. You have a right to do that. You should have a right to withdraw, which means to take back your plea bargain agreement. Now, if the judge does follow the plea bargain agreement, and you decide within 30 days that you would like to appeal your case, in essence, you would like to have a higher court to review your case to see whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. Well, the judge has to give you permission to appeal. If the judge gives you permission to appeal, then your case will leave this court and it will go right upstairs to the Ninth Court of Appeals. There are 4 judges up there. They will review your case to determine whether or not this court wrongfully convicted you, or committed an error by convicting you. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can simply just find you not guilty and the case is over. Or they can send the case back down to this court, ordering this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest court, the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals. Now, you would have to file what is called a pro se petition for review. What that means is this. Pro se means you by yourself, you don't have an attorney, you represent yourself. And you'll be requesting or petitioning that court to review your case to see, 1, whether or not your appeal should have been granted, or 2, whether or not you were wrongfully convicted, or whether or not this court committed an error by convicting you. The Texas Court of Criminal Appeals can do one of two things. They can grant or deny your petition. If they grant your petition, they could just simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your appeal, then at that point, your conviction will stand. Okay. Now, you also have a right to have witnesses to come to court. Well, yeah, you have a right to have, I mentioned to you it was an agreed plea bargain. The other one is unagreed. The unagreed one, you and the state have not been able to reach an agreement, and you want the judge to decide what your punishment will be. That's called an unagreed plea bargain. The judge will apply the facts to the law, and then the judge will determine, based on the law, what your punishment should be, anywhere within the punishment range of your charge. If it was a Class B, Class A, or Class C misdemeanor. Now, you also have a right to have witnesses that come to court for trial. They sit in that chair that has a microphone before it. What witnesses do, they can testify either for you or against you. If you represent yourself, you can ask a question. If you're a lawyer, your lawyer can ask a question. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court, which means that you will not be calling witnesses to come to court to testify. It does not mean that the state will not be calling witnesses to come to court, because they will be calling witnesses to testify. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that means is this: the United States Constitution gives all of us the right to remain silent. We don't have to testify against ourselves. I know a lot of times we see on television where you see a television lawyer go up to the witness stand and ask somebody a question, and they say, "I'll take the fifth." What they're doing is they're exercising or they are invoking their Fifth Amendment right against self-incrimination. And as I usually say, it makes sense why we have that right, because one, well, the state has the burden of proof. They have to prove someone guilty or you guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay. You don't have to do that job for them. Okay. That's why you have a Fifth Amendment right to remain silent. Now, you can waive or give up that right, which means that you can take the witness stand if you desire, if you want to waive or give up your Fifth Amendment right against self-incrimination. Now, if you do so, then obviously, then they can ask you questions. Now, you also have a right to have what is called discovery. Discovery means that you have a right to see the evidence, all the evidence that the state has and will be using against you. For example, you have a right to see your statements, witness statements, police reports, lab reports, video recordings, listen to audio recordings. You have a right to see the documents, instruments, anything that they have that they'll be using as evidence, or that they have to use as evidence against you. You have a right to have access to that. Now, you can waive or give up your right to discovery. If you do so, then you will not be having access to the evidence that the state has and will be using. Now, you also, everyone that's here, you've been, well, charges has been filed on, you've been arrested, placed in the county jail, you bonded out of jail, you're out of jail on a cash bond, which means that you pay the full amount of bond to get out of jail. You're out of jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail. Or you're out of jail on what is called a personal recognizance bond, which means that you need, or a PR bond, which means that you did not have to pay anything to get out of jail. You were released under your own personal recognizance with a promise to appear in court. I've said that to say this: every day that you spent in jail, it can be used as credit towards your punishment. The operative word that I just mentioned was every day. So, for example, let's say you were booked into jail at 11:59 p.m. last night. And let's say you booked out of jail at 12:01 a.m. today, which means you was in jail 2 minutes, right? But you get credit for 2 days. Why? Because yesterday was Monday and today is Tuesday. Okay? So there's 2 different days. So you don't have to be there 48 hours. It's just it's 2 different days. Okay? And so, for example, let's say you're in the state of talk and the state is off, you spent 5 days in jail. And let's say the state is offering you 5 days in jail. That means you don't have to spend no more time in jail, because the 5 days that you spend in jail, you'll be given credit for the time that you've already served. All right? Now, if the state is offering 7 days in jail and you spend 5 days in jail, that means you only have to spend 2 days in jail. Why? Because you already have 5. You're going to subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail also is credited toward your fine and court costs. You are credited $100 for every day that you spent in jail. $100. If you spent those 2 minutes in jail, that's $200 because it's 2 different days. And so if you spent 5 days in jail, the state is offering you credit fine and court costs of $500. You won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, that means you'd have to pay $200 on the day that the case is disposed of. If you cannot pay the $200, no problem. We can put you on what is called a payment plan, where you pay it off in small monthly installments until it's paid off. Now, even if we put you on a payment plan, if you are unable to make the payments because you don't have the income, no problem. Because we can convert the fine and court costs to community service. So every 1 hour community service that you perform in a nonprofit organization, $12.50 will be credited toward your fine and court costs. So for example, if you work an 8-hour day of community service at a nonprofit organization, that's $100. That can be credited towards your fine and court costs. So in our scenario, you work 2 8-hour days, that's $200. You've already paid off your fine and court costs. All right. Now, let's see. Jefferson County has a program for first-time offenders. Now, let's say you haven't had charges filed on you before. It's first time having one or more charges filed on you. Jefferson County has a program that's called pretrial diversion, where they would dismiss your case. Okay? And you could get it expunged from your record. Expunged means erased, deleted, wiped off of your record. Okay. The program is called pretrial diversion. Now, in order to qualify for pretrial diversion, 3 things has to happen. 1, you have to have an attorney to help you with the application process. The attorney could be either court appointed or hired, doesn't just an attorney. All right. The next thing is it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And 3, it has to be your first time getting in trouble. All right. If those 3 things happen, you can get in the program. You complete the case is dismissed. Once you complete the program, you can get it deleted, erased, wiped off your record. We call that expunction. All right. Now, if you're a veteran from any one of the branches of the military service, then Jefferson County has another program that is called Veterans Court. With the Veterans Court program, what they will do is once you get into the program and complete the program, they will dismiss your case. And you can get a non-disclosure where your record is sealed to the general public. Okay, it's Veterans Court. So with Veterans Court, the only thing you have to be is just a veteran of any one of the branches of the United States military. Whether you had honorable or dishonorable, just it doesn't matter. He was a member of the United States military. Okay. Now, the other thing, this court has a program that God led me to start in March of 2017, which was the first 100 days of taking office. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. The program is designed to address the issue of what we call recidivism. Recidivism just means people commit crimes over and over. Recidivism. And so we address that how? Through our CSI program. And in the CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. And we have some folks here from Spindletop Center who's going to come to you in a few minutes and tell you a little bit more about the program that they have to offer. But Spindletop is our local mental health center for the Southeast Texas region. And with Spindletop has the expertise to address mental health issues. Now, you don't have to be incompetent or insane or to participate in the program. You could merely suffer from anxiety, depression, or any other host of mental illnesses, and they have the expertise to address those issues. Now, what they would do today is they can do a private interview either in our jury room, at their facility by telephone, or whichever is convenient for you. They also have the ability to do an assessment to determine what your mental health issue is, and they can develop a treatment plan to address your mental health issue. Now, if you have issues with drugs or alcohol, well, Spinotop has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. And we also have a partnership with our local drug and alcohol council that has a program that is called OZAR, which is an acronym OSAR that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment to determine what your alcohol or drug issues are, and they can develop a treatment plan to address your drug and alcohol issue. If you're unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Poverty Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of the areas that you select, they will help you to get a job in the area that you're trained in. Now, if you didn't graduate from high school, or you do not have your GED, well, CICE also has a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this quote, we don't just give time, we take our time. That simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, and we'll be happy to direct you to the individuals that you can talk to get on the road to living your best life. So at this time, as I mentioned to you earlier, we have some individuals from Spindletop. We have our mental health deputy, Deputy Powell, and we have Tanya from Spindletop. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer. How you doing? Thank you. Good cool. Fast out. Good cool. Deputy Powell, never get in conjunction again. Here's my partner, Tom. Yeah, partners, help the civilian ride together all day long and work together all day. This program started 9 years ago. We had lots of Boston ball shooting with people in the police. So that program was started. If you see now that there's not a lot of that stuff going on, because one, I think our job as mental health therapists is to keep you out of jail and out of crisis. That is our job. So if it's some sort of crisis, when we come to your house and talk to you or follow up with you, you're going to see no phone, you have a desk and everything, it'll be me or among other than things. And would be with a qualifying position, but don't shoot us. We're not, even if you have more, we ain't taking you anyway, that's not what we.
Ms. Tanya, make go over the paper.
I'm wondering about. We're all same thing. Pretty much, we are just here to help you guys with the services that you need for as mental. With the legal side, we don't go in depth with the legal, but if you guys need assistance probably with, the mental issues of legal, if you have to be taken into custody or anything like that, we can help you guys go through the different steps for that mental side. If you guys are already in services, we can also touch base with them, give updates as far as meeting with the doctor or one of the nurses on site. Um, as Judge Holmes was speaking about, we're not just the mental side, you guys, we can help with different areas as well. Be it something with education, something with employment. We're just here available for you to provide any services needed. As if you said, there is a little note on your boards. You want to fill out if you'll have to speak with us directly today, or if you'd rather phone call or email, we have those available as well. Do you have any questions?
Oh. Will come to that, please?
Tanya,
Thanks.
you're welcome.
Okay, anybody have any questions? Okay. Okay, ladies and gentlemen, as I mentioned to you earlier, we're gonna give you time to fill out that paperwork. If you need help filling out the paperwork, just let us know. Because we have our co-personnel, including myself, will be happy to assist you with filling out the paperwork. Now, it's gonna take a little time when you fill out the paperwork and, once you finish the paperwork, we're going to pick that paperwork up from you. And then we're gonna evaluate it, make sure everything is filled out properly. Now, that's gonna take a little time. If you need to use the restroom, there are two restrooms right out in the hallway. The men's restroom is in front of County Court Law number 3. And the female restroom or the women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to use the restroom. Now, once you use the restrooms, you need to come back in the courtroom. Please do not leave the courthouse. Because if you leave the courthouse and your name is called and you're not here, then your bond is going to be forfeited. Once your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. And guess what? We're gonna have to go through this all over again. Okay. And so we want you to go through this all over again. And so we'll try to get you in and out as soon as possible. Now, let me tell you this here. You're gonna be placed in one of 3 categories. One category is you're gonna hire an attorney. If you hire an attorney, your case will be reset. Give you time to hire an attorney. You'll get your reset today, and then you'll be able to go. Second category is if you want to apply for a court-appointed attorney. And if you qualify for a court-appointed attorney, your attorney will be appointed today. Okay? And then we'll reset the case to give you time to talk to your attorney. And then your attorney has to do investigation, talk to you, talk to the prosecutors, etc. Now, if you would like to represent yourself, you'll talk to the prosecutor, and if y'all work out an agreement, your case will be taken care of today. Okay? And so, with that being said, the court is going to go into recess. And before we do that, make sure at the top of the document, there's a line that says State of Texas versus, and it's a blank. Print your name at the top, because the reason why I'm saying print, because a lot of times people put a signature up there, we can't read it. And so if you print it, we should be able to read it, okay? All right, so at this time, the court will go into recess, and make sure that you conduct yourself accordingly, because we are still in the courtroom. Okay, court will be in recess. Thank you. Jefferson County Court at law number 2 is back in session. Cases and the court is in session and calls number 24 CCCR 1096. Case is style of state of Texas versus Kit Dane or Don. Please come forward. Morning. Mr. Don, your full name is Kit Don.
Yes, sir.
How are you doing? How are you doing? You doing good? That's good. Now, Mr. Don, you're representing your case by your attorney, Baltimore Zanega. Mr. Zanega, how are you doing?
I'm doing well, Judge. Thank you for asking.
You're welcome. The state is representing this case by Mr. Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
And Mr. Zanega, what is your announcement for Mr. Don's case?
So, Your Honor, I think at this point, we're ready to set this matter for trial.
Wrong. That's okay.
And I wanted to thank the court for rolling him from yesterday, some of the other matters here in Jefferson County.
Okay, no problem. Okay, your case is gonna be reset for trial, Mr. Don. Our court coordinator, she's gonna give you a reset. Once you get your reset, you'll be free to go. You have a blessed day and Merry Christmas to you. And Attorney Zanega,
Yes,
you'll be free to go as well once you get your reset.
thank you, Judge.
And have a blessed day and Merry Christmas to you as well.
To you as well.
Thank you. Court is back in session. Next case is cause number 25 CCCR 2434, case of style of state of Texas versus Jessica Martell. Martell, would you please come forward? Okay, Ms. Martell, your full name is Jessica Martell.
Yes,
How are you doing, Ms. Martell?
plan about yourself.
I'm doing fine. Thanks for asking. Ms. Martell, the state is represented in this case by Attorney Kenise Williams. Mr. Williams, how are you doing?
Doing well, Your Honor. Thank you.
You're welcome. Ms. Martell, Ms. Martell, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Ms. Martell, you may put your hand down. Ms. Martell, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to hire your own attorney?
Yes, sir.
Okay, Ms. Martell, before you signed and initialed this document, did you read the document?
I
Did you
did,
understand what you read?
I did understand. sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Martell, your case is going to be reset by our court coordinator. Once your case is reset, you'll be free to go. Have a blessed day and Merry Christmas to you.
Thank you, Ms.
Okay, please have a seat in that first chair on the wall. Next case is Reyes Castaneda Jr. Mr. Castaneda, your full name is Reyes Castaneda Jr. You may, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand out. How are you doing?
Good.
I'm doing fine, thanks for asking. Mr. Castaneda, I have before me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line states you'd like to apply for court-appointed attorney? I also have another document. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature on the line that's titled Defendant. Is this your signature? Mr. Castaneda, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Castaneda, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him.
Yes.
Our court coordinator will give you that information, but before she gives you that information, Mr. Williams, could you pass this document to him? The prosecutor is going to pass you a document that is titled Standard Bond Conditions. I need to go over these bond conditions with you. And it states as follows: following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Now, condition number 3 does not apply, neither nor condition number 4. That doesn't apply either. Condition number 5 does apply on the next page, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Castaneda, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Castaneda, just please have a seat in that second chair. Wait for your name to be called. Once your name is called, you'll go to the window and the court coordinator will give you your reset. Once you get your reset, you'll be free to go. You have a blessed day. Merry Christmas to you. Yeah, that's your copy. Don Ray Jones. Mr. Jones, your full name is Don Ray Jones?
Yes.
Mr. Jones, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Jones, you may put your hand down. How are you doing, Mr. Jones?
All right, so,
I'm doing fine, thanks for asking. Mr. Jones, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
yes,
And is this your signature on the line that's titled Defendant?
yes,
At the top of this document, well, there's a set of initials on a line that is titled, that state you would like to apply for a court-appointed attorney. Is that correct? And is this your signature?
yes,
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
yes,
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
yes,
Mr. Jones, before you sign and initial these documents, did you read the documents?
yes,
Do you understand what you read?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Mr. Jones, read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given permission to contact you, and you will also be given permission to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go. But before she gives you that information, Mr. Williams, could you hand this document to you? Mr. Jones? Mr. Jones, Mr. Williams is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you, and it states as follows. Following return of accrued information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol. At any time as directed by the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and condition number 4 does not apply. However, condition number 5 does apply on the next page. Well, no, excuse me, let me back up. Condition number 4 does apply because your offense is a DWI second, which is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense, with written verification of such installation being submitted to the court on or before 3 days after the date. Do you understand that condition?
Yes, sir.
And condition number 5 states that a defendant shall obtain, maintain, and pay for, and have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition?
Yes, sir.
And number 6, defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Yes.
And I have document. Okay, I hand you 2 documents. The first document is a form that you would have to bring in, a sign-in sheet that you bring in every time that you go to your AANA meetings. Sponsor will sign it. And then when you come to back to court, you need to have that form with you so we can verify that you have been attending AANA meetings. The next document has about 3 or 4 pages. On the next document, that's various different locations that you can attend AANA meetings in Jefferson County. You could go to any one of those,
Jessica Martel.
any one of them that's convenient for you, okay?
Yes.
Now, Mr. Jones, if you violate any one of these bond conditions, your bond can be revoked. That door is locked, ma'am. If you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? All right. Please have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll be free to go. You have a blessed day and Merry Christmas to you.
Yes, you too.
Thank you. This document is locked. Neighbors, are the neighbors. Oh, never mind. It came that color. Hey, Mr. Neighbors?
You know, they Judge.
All right. Let's see. Here we go. Okay, this is cause number 23 CCCR 2598. Case is style of state of Texas versus Arlen Neighbors. And Mr. Neighbors, is that your full name?
Yes, sir, it's my full name.
Okay, Mr. Neighbors, would you please raise your right hand? Mr. Neighbors, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Neighbors, you may put your hand down. How are you doing, Mr. Neighbors? You doing well? That's good. Now, Mr. Neighbors, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Neighbors, it alleges that you, Arlen Neighbors, on or about October 14th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense, possession of a controlled substance, penalty group 2A, that had a weight less than or equal to 2 ounces. Mr. Neighbors, do you understand what you've been charged with?
Yes, sir.
To this charge, Mr. Neighbors, how do you plead guilty, not guilty, or no contest?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Neighbors, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this document, okay, on page 2 of the same document, there are a set of initials ON on two different lines. The first line is next to a line that has the word guilty. Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph and is next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter a plea of guilty or no contest. Is that, did you
Yes,
place
sir.
your initials there? On page 3 of the same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court oops. Okay, on the next document, that's titled trial court certification of the defendant's right of appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir. That's my signature.
Crazy. It was
Okay.
flashing back.
Oh, it was?
Yeah.
Yes,
Now it's
sir.
on there.
Okay, and at the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper, two documents on paper. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes.
defendant? And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant?
sir.
Now, Mr. Neighbors, before you sign and initial all of the documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Neighbors, are you a citizen of the United States?
Yes, sir.
Staying
State?
over States Exhibit 1.
Now, the state, let me do this here. I need to back up a minute. Now, before we got started, I forgot to mention to you that you had a right to have a court reporter to dictate or type down everything that's being said. You also had a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
I will even give up my right for a court reporter.
Okay, now, Mr. Neighbors, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is this first document that I showed you on the tablet. It's the same document that have your initials in these two locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's Exhibit Number 1 will be admitted. Now, Mr. Neighbors, is there any evidence that you are currently mentally incompetent to stand trial?
Jones.
No, sir.
Okay? Now, Mr. Neighbors, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now,
Yes, sir.
state, do we have a plea bargain agreement?
Yes, we did, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 4 days county jail with credit for time served of 4 days. And that's that the court costs in this matter be taxed and retired.
Okay. Mr. Neighbors, the state is offering that you serve 4 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 4 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. Mr. Neighbors, the court costs in this case will be taxed and retired. That simply means that the time that you spent in jail has already paid it off. Therefore, the court costs will also be taxed and retired. Now, Mr. Neighbors, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Neighbors, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Neighbors, This will conclude your case. You're gonna stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll be free to go. And you have a blessed day and Merry Christmas to you.
Thank you so much. It was nice to meet all of you. Y'all have
All
a
right.
great day.
Merry Christmas to you as well. Bless you.
See what I'm up.
Jefferson County Court at Law number 2 is back in session. The court is in session in 3 cases. They are cause numbers 25 CCCR 2348, cause number 25 CCCR 2349, and cause number 25 CCCR 2482. All 3 cases are styled of state of Texas. versus Gerald L. Michael Banks. Mr. Banks, is that your full name? Mr. Banks, would you please raise your right hand? Mr. Banks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Banks, you may put your hand down. How are you doing, Mr. Banks? I'm doing fine, thanks for asking as well. And Mr. Banks, before we get started, you have a right to have a court reporter to type down everything that's being said. And you have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, ma'am.
Okay. Now, Mr. Banks, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to waive or give
Yes, sir.
the right to have an attorney? I have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? Now, Mr. Banks, I also have before me a document on my computer that is titled Information.
Yes.
This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Gerald L. Michael Banks, on or about August 28th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Banks, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Banks, how do you plead? Guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Banks, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials is on the line next to a box that's checked nolo contendere, which means no contest. Do you recognize this document?
Yes, sir.
On page, on the same document, but the paragraph below, there's a set of initials below the paragraph that is titled Discovery Admonishment and is on a line that states, I do not request discovery. I waive my right to discovery in this case. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Banks, before you signed the initial, all of the documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
Yes, sir.
Mr. Banks, are you a citizen of the United States?
Yes, sir.
State offer State's Exhibit 1.
Now, Mr. Banks, the state is offering State's Exhibit Number 1 to be used against you as evidence in this case. State's Exhibit Number 1 is this document. That's the first document that I showed you on this tablet that's titled Trial Court Certification of that's titled Misdemeanor Plea Admonishments. This is the same document that have your initials on page 2.
Yes,
It also has your signature on page 3. Is it all right
Yes,
for the state to use this document as evidence in your case?
yes, sir.
No objections. State's Exhibit Number 1 will be admitted. Mr. Banks, is there any evidence that you are currently mentally incompetent to stand trial? That means, do you have any mental issues that affect you ability to understand what's going on right now?
No, but I do
You-
take medicine. I'm in Spinatok.
Okay, but you understand that you're entering a plea
Mhm.
of no contest, and you understand that all of the information that you read in these
Yes.
waivers?
Yes, sir.
Okay. Okay, this court is going to find that you are mentally competent to stand trial. Now, Mr. Banks, the court is going to accept your plea of no contest. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, we do, Your Honor.
And what is the agreement?
Is this on 2348? I'm on.
4A. Yes.
Okay. We would ask the court for 90 days county jail, probated for a period of 6 months of community supervision. State agrees to waive a fine, ask for repayment of the court costs, and 24 hours of community service. Mr. Banks has 2 days credit to go towards his court costs in this matter. And we'd ask that this sentence run concurrent with the companion case 25 CCCR 2482, and the state has agreed to dismiss cause number 25 CCCR 2349.
What's the court cost?
270.
Two to seven. It's pretty. Okay, Mr. Banks. The state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 6 months. During the 6-month probationary period, you will not be required to pay a fine. You will be required to pay court costs of $277, but since you have 2 days credit, the court costs will be $77 instead of $277 because you have 2 days credit. You also be required to pay a probation fee of $60 a month. You'll be required to pay a urinalysis fee of $15 a month and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay, is $108 a month.
Yes, sir.
Are you able to pay the $108 a month?
No, sir.
Okay, that's not a problem. Do we give him a affidavit? Could we give him an affidavit? Do you, okay, she's gonna check first.
He was finishing.
Oh, he did, he started one?
Yeah, he doesn't.
She's gonna let you, he can have a seat, and if he needs to fill out, let him know the part that he needs to fill out.
I'm gonna have to get my mom there.
Okay, well, she can help you, I mean, it's Banks.
Yes, sir.
I have before me a document that's titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
And Mr. Banks, is everything in this document true and correct?
Yes, sir.
Okay, Mr. Banks, the court is gonna find that you're indigent. Let me see. Oh, that's 77. That leaves the $90 divided by 5. Okay. Mr. Banks,
Yes, sir.
the court has found the indigent, which means that you have an inability to pay. So the $77, well, the $77 court costs that you were required to pay, that will be converted to 6 hours of community service. The probation fee of $60 a month will be waived pursuant to Article 42A.652 B of the Code of Criminal Procedure. 65, let's see, 42A. Because the court has determined that the payment of the reimbursement fee, which is the probation fee, would cause you to have a significant financial hardship, so you would not have to pay that. The reimbursement fee of $15 will be waived pursuant to Texas Code of Criminal Procedure, Article 102.018. And which means you won't have to pay that, and so you will be required to pay a urinalysis fee of $15 a month.
Mhm.
The total monthly installments in this case is $18 a month. Okay,
Gotcha.
now, Mr. Banks, you will also be required to perform 24 hours of community service
Yes, sir.
in addition to the 6 hours that was converted from the court calls, which comes to a total of 30 hours of community service. And you will also be required to adhere to the other standard terms and conditions of this probation. The state will be dismissing calls number 25 CCCR 2349, and this case will run concurrent with calls number 25 CCCR 2482. Mr. Banks, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in this case is fair and just?
Truly, yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Banks, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Banks, we'll move on to your next case, calls number 25 CCCR 2482. And in this case, Mr. Banks, I have a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Banks, it alleges that you, Gerald L. Michael Banks, on or about July 28th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of failed to identify by giving false or fictitious information. Mr. Banks, do you understand what you have been charged with in this case?
Yes, sir.
And to discharge Mr. Banks, how do you plead? Guilty, not guilty, and no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Free.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Banks, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials, GB, are on a line next to a box that's checked nolo contendere, which means no contest. You place your initials on this document.
Yes, sir.
Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea guilty or no contest. You place your initials on this line.
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that is titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document.
Yes, sir.
And is this your signature on the line? Is titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand this
Yes,
statement?
sir.
Now, Mr. Banks, before you sign and initial all of these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the
Yes,
best of your knowledge? And you previously signed the judge's explanation of rights to defendants without attorney, whereby you stated that you wanted to waive your right to an attorney, and you initialed that line. Is that correct?
Yes, sir.
You also signed a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Is that
Yes,
correct?
sir.
Now, Mr. Or State, do we have, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Any objections to State's Exhibit Number 1, which is the misdemeanor plea admonishment? No objections. State's Exhibit Number 1 will be admitted. And Mr. Banks, the court is going to accept your plea of no contest. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. The court will also find that your plea and waivers, that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 90 days county jail, probated for a period of 6 months of community supervision. We ask for a fine of $250 plus repayment of court costs and 24 hours of community service. Mr. Banks has 4 days credit towards his fine and court costs on this charge, Your Honor. And we'd ask that this sentence run concurrent with the previous case. And again, the state agrees to dismiss cause number 25 CCCR 2349.
Okay.
Home statement. Home statement.
Let's see, 250. What's the court cost?
277.
277. You got 4 days credit. How many hours of community service in this? You said was, no, in this case,
24.
24. Okay. Okay, Mr. Banks, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 6 months. During the 6 months period, you're required to pay a fine of $250. Well, the fine in this, you'll be required to pay a fine of $250. You'll also be required to pay court costs of $277. You'll be given 4 days credit towards your fine and court costs, which that's $400 is going to be subtracted from the $527, which leaves a total of $127. The court has previously found that you're indigent and that $127 fine and court cost balance will be converted to 10 hours of community service. The probation fee in this case, you will not have to pay because it was in your previous case. And it was waived pursuant to Article 42A.652B, Texas Code of Criminal Procedure. And the urinalysis fee in this case you paid it in the previous case, so you don't have to pay it in this case. The reimbursement fee will be waived pursuant to Article 102.018 of Texas Code of Criminal Procedure. And so therefore, in this case, you would have to do just the 34 hours of community service. Now, this case will run concurrent with cause number 25 CCCR 2348, and the state will be dismissing cause number 25 CCCR 2349. Now, you also have to perform 24 hours of community service in this case. That 24 hours of community service is in addition to the 10 hours of community service, which comes to a total of 34 hours of community service. Do you understand?
Yes, sir.
Okay. Now, do you understand the state's offering the findings that the court have made in this case?
Yes, sir.
And do you think that it's fair and it's just?
Yes, sir.
And do you accept?
Totally fair. Yes, sir.
Okay. Now, Mr. Banks, the court is going to follow the plea bargaining agreement with the findings that the court have made based on you being indigent. And this will conclude your case. Now, Mr. Banks, see that you're here with someone. Somebody's here with you. Your mother? Ma'am, thanks for coming down here with your son. Now, Mr. Banks, once these cases is over, you'll be free to go. And I know earlier this morning, you had a lot of anxiety
Yes, sir.
that was built up. You was thinking you was going to jail,
Yeah.
but
I haven't been taking my medicine. I need it.
okay. Well, that's a good thing. Okay. Now, Mr. Banks, I know a lot of times. Well, first of all, let me ask you, how old are you?
I'm 30.
30. Okay.
Sorry, 30.
You know what? I used to be 30 for 365 days. I was 30. Yeah. Yeah. It was many moons ago.
Yeah.
And you know, Mr. Banks, you know, when I was 30, I put a lot of stock in my friends. You know, I had friends, and I know you have friends too. Young people these days call them their BFF.
Yeah.
Best friends for life, or they
Back in my-
ride or die. Okay, you had your ride or die. Those are the individuals who say, boy, you know what? When I'm down and out there, be there for me. When I'm, you know,
Used to
yeah,
grow up.
well, and you kind of thinking that person will be there with you through thick and thin. You know, but on days like today, when you need a friend, them people that you call your ride or die is not here. But
Sir.
that lady that's in the back there that you call mama,
Queen.
she's here with you. And you know, that's the lady that put a roof over your head, put
Yes.
clothes on your back, food on the table, and every now and then I know she had to put a little spanking on your butt.
Yes, sir.
Okay?
Yes, sir.
And she did all of those things because she loved you.
Yes.
And that's why she's here today. It's because she loved you. And I tell people this, young people this all the time, everybody's not your friend, everybody's not your partner.
That's true.
But when that lady right there says she got you, she got you.
Oh, yeah, that's true.
That's right. And so before the day is over, you need to give that lady a big hug and put a kiss on her cheeks.
That's overstated.
Yeah. Now I know a lot of times, you know, this is not the proudest moment of your mom's life, but you might also be thinking that you're in a storm. But guess what? Just remember this: when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. And there's one thing about hope: hope floats. So
That's true.
when you're drowning in the sea of confusion, you can hold on to hope to keep your head above water.
That's the God's honest truth.
Okay. And so, Mr. Banks, you know, your mom is there. And Mr. Banks, you know, some people might look at this here today as a stumbling block, but guess what? You could look at it as a stepping stone. And people use stepping stones to reach high
Oh,
heights.
yeah. Sure, for sure.
And so you can reach higher heights in your life.
Yes, sir.
Okay, just continue to stay strong. I tell people this here, my mama, don't give up on him. Hang on, don't hang up.
She never did.
All right. Just stay with him, he'll be all right. Sometimes some people it takes a little time to learn. Okay. We call him a late bloomer.
Overstated.
Yeah, I was a late bloomer. Okay.
True.
But you just gotta just believe in yourself. If you believe, you can achieve.
That's true.
Okay.
That's
It's all about your belief. And make sure you cooperate. You know what you need to do. Just make sure you do those things.
Yes, sir.
All right.
Yes, sir.
You're gonna stand next to the bailiff. Follow her directions. Once you follow her directions, you'll be free to go. Merry Christmas to you, and ma'am, Merry Christmas to you as well.
Merry Christmas to you.
All right.
Great day. Thank
All
you.
right. Yeah, have a blessed day. All right.
Right.
Holmes be another one. Okay.
And a dismissal.
And dismissal, judge got us.
Jefferson County Court of Law, number 2 is back in session. Court is in session. And calls numbers 25 CCCR 2180 and calls number 25 CCCR 2203. Both cases are styled the state of Texas versus Javier H. Arta. Mr. Arta was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Javier Arta at the courthouse door. Mr. Arta did not answer. Mr. Arthur has not appeared in court since the court has been in session. The time now is 12:19 p.m. on today's date. Ms. Bailiff, would you please call the name of Javier Arta at the courthouse door?
Javier Orta. The response from.
Okay, Javier Arta's name was just called again at the courthouse door. Javier Arta did not answer. A reasonable time has passed to give Mr. Arta opportunity to be in court. He has not appeared in court. State, do you have a motion in Mr. Arta's cases?
Bond forfeiture warranted, Your Honor.
Okay. Javier Arta's bond will be forfeited and a warrant shall be issued for his arrest in cause numbers 25 CCCR 2180 and cause number 25 CCCR 2203. Next case is cause number 24 CCCR 0414. Case is styled the state of Texas versus Raya Lene Young. Ms. Young was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Raya Young at the courthouse door. Raya Young did not answer. A reasonable time has passed to give Ms. Young an opportunity to appear in court. She has not appeared in court. The time now is 12:20 p.m. on today's date, December 9th, 2025. Ms. Bailiff, would you please call the name of Raya Young at the courthouse door?
No.
Yes.
Raya Young. No response from.
Raya Young name was just called again at the courthouse door. Raya Young did not answer. A reasonable time has passed to give Ms. Young an opportunity to appear in court. State, do you have a motion?
Yes, Your Honor. State will move for bond forfeiture and warranty issue, Judge.
Okay. The court will grant that motion. Ms. Young bond will be forfeited and warrant will be issued for her arrest in cause number 24 CCCR 0414. Okay, and this will conclude the calling of the court's arraignment docket on today's date, December 9th, 2025, in County Court at Law number 2, Judge Terrence L. Holmes presiding. Prosecutors, you are excused. All right, everyone, please have a blessed day.
Thank you.
You're welcome.